afternoon, and I'll add my thanks for coming along to a GDPR talk on a Thursday evening. You could be in the pub, you could be doing all sorts of other things, and you've chosen to think and talk about GDPR. So well done on that one. Before we start, for those of you who haven't been to one of our presentations before, a bit about us. So well, 10, 12 years ago, before I set up the firm, used to work on the dark side of law. So sort of doing $500 million plus M&A, a lot of sort of emerging markets work. Terribly glamorous, all good fun. And then I realized about, 2011, that I'd worked with some sort of bigger startups, what we would these days probably call unicorns. Really enjoyed it, found it a little bit more interesting than some of the stuff I had been doing. And so quit the firm I was at and set up Buckworths. As Ivan said, we're the only firm in the market working exclusively with startups. Loads and loads of our competitors obviously do bits of startup stuff to a greater or lesser degree. I think the fun thing I would say about us and about my life is that we see all sorts of different ideas. We get stuck in at the very beginning of of startup lives, and that gives us a really interesting perspective and an ability to help founders get stuff set up in the right way. So in terms of what we're going to talk about today, quite a lot to get through, but the good news is we are really focusing on the sort of the big ticket stuff. So 20,000 foot perspective, we're not going to go into massive granular detail. For those of you who've had the joy of looking at the Data Protection Act 2018 and GDPR, you'll know it's super complicated. There are hundreds of thousands of pages of guidance. Really, this is just sort of flagging to you guys the things that you need to think about. So hopefully not too painful. As we go through, if you do have any questions, chuck them in the chat box and we'll get them in the end. So to start with, I thought it'd be useful just to put a bit of context around this. So why all the data protection laws out there, and there are data protection laws that we'll talk about all over the world. What sort of things are they trying to do? So there's a bunch of sort of commonality in most jurisdictions now about the aims of the data protection rules. So the first one is, and the biggest thing, we're looking at protecting individual privacy. So when you interact with a platform, so let's say you sign up to ChatGPT, or you sign up to an online banking app, you are going to chuck a whole bunch of your personal data into that app. You expect, quite rightly, that the person you give that information to will treat it properly, will not sell it to people, will not give it to fraudsters, that your data is safe. And that, I guess, is number one, the most important thing that we're trying to achieve. Beyond that, most data protection regimes are sort of focused on setting standards. So we'll talk a little bit about things like data minimization. So the idea that businesses shouldn't take more personal data than they need, making sure that when personal data is taken, it's taken for specific reasons and only used for those reasons. So, a good example might be, if I sign up to a platform, I give them my email address. That email address is, I'm told, will be used to create a profile for me, to send me marketing communications and other communications that are relevant to me. I am fine with that. I've signed up, I've agreed to that happening. What wouldn't be acceptable is for them to then sell my email address to other people. That's not part of the deal. That's not what I've agreed to. Other sort of things to think about, making sure data is kept accurate. There's an ongoing obligation on companies to make sure the data they hold about people is up to date and accurate. Making sure that data is only stored for as long as it's needed and for a reasonable period of time, and making sure it's kept confidential. So those are sort of the standards that you tend to see imposed by different regimes. A really important part of UK and EU legislation in this space is actually around what we call empowering individuals. So this is basically saying that you as an individual you have rights in respect of your personal data, and there's a load of stuff that you can and you have the right to do with it. So you can, in some circumstances, ask businesses to delete your personal data, so delete the data they hold about you. You can ask them to correct data that is incorrect that they hold about you. You can ask them to give you a copy of it. So these rights are super important, and they give you the ability to control what happens to your data. The next one, which I think is super important, is accountability. So, if businesses get this wrong, and of course it happens, they are held accountable for that. And that really comes in, two main ways. Mainly, and the most important one, is that the regulator is able to sanction. And the ICO, which is the regulator in the UK, can issue fines, they can issue sanction notices if businesses are getting this stuff wrong. So accountability is super important. Facilitating safe data transfers is something that I think a lot of businesses forget, and actually is one of the more difficult areas of personal data. But what we're getting at here is the situation where you have given your personal data to a business, and they need to transfer that data to another business for one of a number of reasons. So a good example would be you sign up to well, actually, us as a law firm, right? You wish to become a client. So what happens is you will give us certain information about yourself. We will then take that information and we will put it into third-party anti-money laundering software. Why do we do that? Well, we have a legal obligation to ensure that we've identified you and we've made sure you're not a terrorist, you're not sanctioned, you're not a money launderer. So we move your personal data to that third-party software. You are perfectly legitimately entitled to expect that that data is safe, that the way that we transfer it to that third party is done in a safe way, and that third party will look after your personal data. And that's really what we're talking about by transfers of personal data. And finally, I guess the obvious one, it's about building trust between people who have got your data and you as the data subject. So there are two ways of looking at the data protection regime. I actually think that most businesses are on the problem side. So they view this as a pain in the proverbial, it's a problem. And that, in part, I think is the fault of lawyers. So lots and lots of GDPR presentations that you might go to or have gone to will sort of shout at you about, if you get this wrong, you're going to get fined by the regulator, you're going to get sued by data subjects, or perhaps by people who have passed data to your business to enable you to do something with that data for them, or by another person. So there's that risk of being sued and financial damages. And then, lots of lawyers will say to you, if you get this wrong, it will trash your reputation, potentially you'll go bust. Now, all of those things are, of course, true. That, there's a lot of sticks involved in this. And that's a sort of, really important thing to remember. If you don't get this right, yes, of course, you can have a load of financial problems that arise from that. But I would actually say for you guys, particularly at the early stages of setting up a business, you should try and flip the narrative a little bit. This is actually about opportunity. And I would say if you can get your data protection compliance right, and you can build it into the sort of the creation and the design and the build of your business, then actually this is a great opportunity. So the two things I would sort of focus on. Number one, this is an opportunity to optimize user experience. So, as I said a second ago, a principle of the UK EU regime and actually most other jurisdictions is that businesses should only collect the personal data that they actually need, and they shouldn't start collecting personal data just for the hell of it. So that's that sort of data minimization concept. All of you guys who are operating tech businesses will know that your user experience people will not want to collect more detail and information than they need to up front. The idea is you want to onboard people, get people up and running with your product as easily as possible. So you want as fewer barriers as possible. If you start asking for all sorts of random information, it slows it down and there's an immediate drop-off. People can't be bothered to fill in the form. And I, for one, I routinely do this. I'm very interested in a service. I go through, I want to play with it. And things that kill it for me, having to put in my credit card details, even if it's for a 1-month free trial, pisses me off. I probably don't bother. Equally, putting in a whole ton of information about, what my business is, am I a director or not, all this kind of stuff. It's not necessary and it causes me to lose interest. So you can optimize your data protection compliance by optimizing user experience and minimizing the data that you collect. The second sort of parallel point here is around collecting data when you need it, not all up front. So if you think about a lot of software platforms, what they need to create a user profile for you is your name and your email address. Maybe it's not even your name, maybe it's just your email address. That gets you a user profile. It gets you on their system. You're using stuff and enjoying it and thinking it's great. There's another point later when they need further information from you. So perhaps they're a premium model, right? Sorry, freemium model. So free to play around with it. But if you want to access certain functionality, you need to pay a fee or sign up for a subscription. At that point, the platform needs more information. So they need your name. They need, perhaps an address. They need some credit card details. So only at that point do you collect that information. And then it may be that actually later down the line, there's further things that the business would like to know about you, and they collect it at that point. So breaking down into sort of layers, the information and the personal data that you're collecting optimizes your data protection compliance and your user experience. So that kind of thinking is the sort of first opportunity that I would think about and point out. The second thing is actually around being really open about empowering data subjects. Data protection is one of those slightly funny areas where I think increasingly a lot of individuals view what happens to their personal data as important. I think, we've certainly seen over the last couple of years, more people asking us, what happens to my personal data? Why do you need this? What are you going to do with it? And equally asking our clients the same stuff. So if you can build a platform that is upfront about this, and you're saying to clients, personal data is yours. This is why we collect it, but you can choose to a degree, but you can choose whether or not to give us personal data. So if you want to, be signed up to marketing emails, then great, sign up to marketing emails, but we're not going to force you to do that, and you don't need to do it. If you want to get access to some additional insights, perhaps, great, then we'll need to take this information off you, but that's entirely up to you. You don't have to do that. And so giving choice to data subjects is increasingly more common, but actually is a really good way, again, of improving the experience that your customers have whilst optimizing your data protection compliance. Some businesses are going even further and are actually giving users the ability to monetize personal data. So a really simplistic view of this would be, or a really simplistic example would be, you give your email address to a platform. By default, almost all platforms, at least in the UK, will not sell that data. And there'll be a clause in their privacy policy that says, we will not sell your data without your consent. But some platforms are actually saying to customers, if you opt in and you allow us to sell your data, perhaps to certain restricted people, then we will pay you. We'll give you a fee for that. That's useful. And another area where this happens is actually in the sort of biotech, medtech space. So we've got a couple of clients who are actually saying to patients, so it tends to be sort of patients with rare diseases, they've got some really fascinating information that the startup wants to be able to play with and wants to be able to use and investigate and adapt. But it's deeply personal, and it's not stuff that you can just expect people to give you nice and easily. So a couple of our clients are actually saying to patients, look, we get this is your personal data. We get that it's important to you. We're prepared to pay you a fee to use this data. You can withdraw the use. You can stop paying at any point in time, but we'll monetize it for you. The final point, I think, around empowering data subjects is sort of around giving people control. So as we touched on a second ago, the UK and EU data protection regimes already give data subjects a lot of control. They have a bunch of rights to request deletion, to request copies of data. Front-loading that, putting that up front, this is what you are entitled to do, is again a really good idea, and I think helps sort of build that sort of positive approach. So a little bit more detail now around some specific points. So we've talked a little bit about personal data. What do we actually mean? So it's basically data that identifies, whether directly or indirectly, an individual. So the easy examples are name, address, contact details. And by the way, there's a myth, because it was a position under the old data protection legislation, that business email addresses are not personal data. In many cases, they are personal data. So don't assume that just because you've got a business email address, it isn't personal data. It probably is. So all of that sort of contact detail stuff. But other things that are also personal data, can be geolocation information. So, you're looking at an app on your phone, it's collecting geolocation data. That is probably personal data because it relates back to a user profile that the business, the app owner has connected with you. Website identifiers, cookie strings, how people are using websites, how they are moving through the platforms. I'm sure all of you have discovered that if you go on Amazon or you go on ASOS and you start looking, let's take ASOS, you look at a particular product, that later when you log back in, it will send you, if you don't buy it, it will send you examples of similar products. I actually remember a couple of years ago, I was looking at ASOS, I was looking at dresses because my mother had asked me to buy her something. And to my slight surprise, next time I logged in, I was getting pushed all of these dresses, which not really my style, didn't really suit me, but I was trying to figure out what was going on. It was because of the sort of cookies and the way they tracked me through the website. So all of that is personal data. And as you set up your business, you need to be aware of that. Figure out what data it is that you're collecting, and as we'll talk about in a second, what you're going to be doing with it. Special category data is basically data that I guess you could say is more sensitive. So it's information about people's race or ethnic origin, sexuality, genetic data, medical data, biometric data, all of that kind of stuff. I think the really important thing that you need to be aware of is that if you are collecting special category data, you have enhanced obligations around it. And we'll sort of talk about that in a sec. What I would say, if we just think about this data minimization point, is, don't process special category data unless you actually genuinely need it. It is more onerous, it is more complicated. You can make your life so much easier by just not collecting it. It's also worth just being aware that you can process special category data without specifically asking for it. So the good example would be, something banal. You're operating a dating app for people who are gay. You can assume, not inevitably perhaps, but you can assume that most people using that app are gay. And so by extension, you potentially have got access to special category data. Whether you record it or not is probably the question that decides whether you're processing it or not. So in terms of the law that we're talking about, in the UK, the law comes from two places, I guess, conceptually. So if we go back to those dim and dark times, I don't know about dim and dark actually, but we go back to sort of pre-Brexit. So back to 2018, we were a member of the EU, and the EU passed what's called the General Data Protection Regulation. So you'll have all, I suspect, heard of GDPR. It came into force on the 25th of May 2018, and it was implemented into UK law by the Data Protection Act 2018. Now, when we left the European Union, so when Brexit happened, that EU version, because if you think about it, it's EU law originally, the EU version of GDPR ceased to apply in the UK. But what we did is we took the version of EU GDPR at the second of Brexit, and that became what we refer to as UK GDPR. So the day after Brexit happened, UK GDPR, EU GDPR, exactly the same stuff, and they said the same things, but they are two technically different bits of legislation. So where we are now is the Data Protection Act 2018 is the governing legislation. It effectively implements UK GDPR. One of the interesting things that is happening and will continue to happen going forwards is that differences are being sort of built in to the UK approach and the EU approach. And we'll talk about the impact of that in a sec. But broadly, at the moment, the UK and the EU are in agreement that our two regimes are broadly equivalent. And that means that you can move personal data between the UK and the EU effectively frictionlessly. You don't need to put a whole bunch of paperwork in place. If at some point in the future it transpires that the UK goes off on a different course and our versions of GDPR become materially different, that will potentially change. And I think, the current government, in their wisdom, occasionally come out with some suggestions that they want to change UK GDPR. They want to, remove bureaucracy, make it easier for businesses. My view, for what it's worth, is that whilst that's a nice idea, what they would actually do is make life much harder for businesses, because businesses would suddenly have to comply with the UK version of GDPR. And then if they're doing business in the EU, as frankly a lot of businesses are, a separate, different EU version. So, something to keep an eye on how the laws sort of go forwards there. It's not all about the UK and the EU, though, and it's super important to be aware of this. Lots of other countries have data protection regimes. So the ones that come up most often are the ones there on the right. So CCPA, which is California, if you process more than a certain number, personal data about more than a certain number of data subjects residents in California, and don't quote me, but I think it's 50,000, then you become subject to compliance with CCPA. Similarly, we come across Canada, Australia quite a lot as well. All three of those are, with some differences, relatively similar to the UK regime. So they are, relatively similar. In terms of trying to figure out which laws apply to you, what you sort of need to think about is a couple of things. So it's the first question is, in which jurisdiction are you processing the personal data? So what we are thinking about here is for most businesses, where are your CRMs based? So where, if you're using a sort of client record management system, where are the servers? So physically, where is that data being processed? And let's imagine, as is very often the case for a lot of businesses, you are processing data in a mix of UK, EU, US. So if you're using Google services, so perhaps you've got G Drive or you've got Gmail, there's a very high chance, I think probably certainty, that that personal data is actually sat in the US somewhere. So what you've got is you've got a transfer of personal data from the UK to the US. So you need to be aware of and compliant with US rules, at least in terms of how that transfer takes effect. Most businesses, have got some processing in the EU. So, you've got a software provider whose servers are based in the EU is a really simple example. So that means that you've got personal data moving from the UK to the EU. And as a UK business, inevitably, you're going to have personal data sat in the UK as well. So that first question, where are you processing personal data? In my examples, that's covering all three of those jurisdictions. The next question is, the data subjects whose personal data you're processing, where are they located? So the crucial, really important point here about EU GDPR is that if you are processing personal data about, let's say, French nationals, even if that personal data is processed in the UK, you are still subject to EU GDPR because you're processing data about EU residents. And a very similar approach, for example, applies in other jurisdictions. So that second point is basically where are your data subjects based, and therefore which regime is applicable to you. And then the final thing to ask yourself is, are you transferring personal data to any jurisdiction? So with that example with Google I gave you, that we're using Gmail for our emails, what is happening is you are popping personal data, let's say about UK data subjects, into G Drive or Gmail, and that data is moving from the UK to the US. Because of that, you have to make sure that there is a valid transfer, if you like, and we'll talk about these in a sec, but it basically means that you have a US connection. So if you look at this little table in the middle, you are smack in the middle of those three circles. So what do you need to do at a high level? The first thing that you need to do is you need to figure out what personal data you're processing. And this is something that in an ideal world happens pretty much at the get-go. It's something that will change over time as your business grows and develops. But at the starting point, when you're setting up your business, you want to have a very clear idea about what personal data you're going to process. The next thing that you're going to worry about is how are you going to process personal data in compliance with the law? And there's a sort of a couple of bits to this. The first one is, as we'll talk about on the next slide, there's a bunch of principles that you have to comply with to make sure that the way you're treating data is lawful. And then there are a bunch of processing conditions that you have to comply with. So this is what's called the legal basis. And when we talk about processing conditions, we're thinking about, things like consent. So the data subject's given you consent to process their data in a specific way. Once you've done all that analysis, you have to figure out what information you're going to tell your customers. So you have a legal obligation to explain to your customers what personal data you process, what you're doing with it, and the legal process for the processing activities. And the way you do that is by publishing a privacy statement or a privacy policy. And then the sort of final bit, if you like, is you need to identify and manage the risks. So data protection is all about risk. If you are doing something that is high risk, you're going to need to do more work, put in place more paperwork, more risk assessments to demonstrate that you are processing in a compliant way. If it's low risk, you don't have to do so much. So to take a really banal and simple example, if the only personal data that you process is the email address of your users, because, I don't know, you're providing a general information site about GDPR, you don't really need any information about your users, you don't track how they move around your website, it's a nice, simple platform. All you do is take their email address so that you can send them a monthly update on changes to the law. That's extremely low risk. So you would probably, frankly, get away with just publishing a privacy policy, so telling people what you do with the personal data. Other end of the spectrum, you are processing personal data about people who have got, a serious illness, let's say cancer. You are processing their medical data about the treatments they've had, how their cancer's reacted to it. You're analyzing that data. That stuff is super high risk. It's special category data, and you can imagine the problems and issues that would arise if that data got into the wrong hands. So that's super high risk. You are going to be a hell of a lot more careful about what you're doing. You're going to make sure that there are really robust agreements in place with every single person who has access to that data. So in terms of lawful processing, so that's sort of, where were we? Second and third point on the previous slide. So there are 6 principles that businesses are required to comply with. These are, I would say, sort of relatively self-explanatory. If you want more detail on any of this stuff, by the way, if you go on the regulator's website, the ICO website, they've got pages and pages of very helpful guidance. So, for example, on the 6 principles, they have high-level summaries that explain loosely what they are, and then they've got, really detailed analysis of what each one is and how you comply with it. But the 6 principles are that you have to process personal data lawfully, fairly, and transparently, which basically means that you have to comply with the processing conditions we'll talk about in a sec. You have to process data in a way that is, predictable and reasonable, and you have to explain clearly to your customers what you're gonna process and what you're gonna do with it. And that really comes down to a decent privacy policy. You have to be explicit about the purpose around which you collect the data. So if you, as we said earlier, if you are collecting email addresses from your customers and you say to those customers, we are only going to use this email address to create a profile for you on our platform, it is absolutely not acceptable for you to then start sending them spam emails using that email address, because that is a different purpose. You need to figure out, when you do your privacy policy, every single thing that you will do with personal data, and make sure that that is clearly documented and visible for your customers. You need to ensure that information you collect is adequate, relevant, and limited. So this is really sort of coming down to these data minimization points, that you should collect the data you need and no more. And you should ensure that the data you're collecting is relevant to what you need it for. So, a really banal and slightly silly example would be around dates of birth. So, if you need to know someone's age for whatever reason, let's say you've got a dating app and you want to put people in boxes, where are you 30 to 35 or 40 to 45? You have to ask yourself the question, do I need to know their date of birth, or can I simply know their age? Is it enough for me to know they're 35? Or do I need to know that they were born on the 1st of April? No, my maths is off, whatever year that would be. So those sorts of things are the kind of questions you should be asking yourself. As we said earlier, you have an obligation to ensure that data is accurate. Now, this is a slightly odd one, because we all know that people provide you with information, and no matter how many times you ask them to update it, people don't bother updating stuff unless and until it's relevant to them. So, I mean, we as a firm have this problem the whole time. We have all sorts of shareholders of our clients. We have their addresses on our shareholder registers. Those addresses get out of date. Most investors and shareholders don't bother telling us. They tell us only when it's relevant to them, which is generally when they're signing another investment round document. At that point, they pop up and say, our address is wrong. So you have an obligation to ensure that data is accurate. How you address that is sort of up to you, and is sort of a risk-based approach. If we're talking about, you know, the address of shareholders on your cap table, I would suggest to you it's not massively important. Really, that is about identification in the long run. Whereas if we are talking about a situation where you are giving, you know, you're a medical platform providing medical services to your patients, it is extremely important that, you know, you need to know if there's any change in their health, or, you know, maybe you even need to know their current address. So understanding how important accuracy is always going to be based on your own business, but, you know, important to remember. You need to retain data for no longer than is necessary. Now, this is something that most startups and most businesses, frankly, get really badly wrong. So I would suggest to you that a lot of businesses simply collect personal data and they hold it forever, basically. They may, if they've thought about this, they may go through their data sets and delete them after a period of time. So they will perhaps say to themselves, well, maybe we'll look at this annually. You know, people who we've had no involvement with for the last 10 years will delete their data. But I think there is always an instinct with businesses to think, well, why would we get rid of information about old clients? Because what happens if they pop up and they come back? You know, we look really stupid if we deleted all their data. You just need really here to think about what is reasonable and what balances the risk. So, you know, if you are holding medical data as a perfect example, that's the kind of data you don't really want to keep holding on to unless you need it. So, you know, you might say to yourself, as soon as somebody deletes their profile with our platform, we'll give it a month and then we'll delete their data. You know, that would sort of make sense. It's high risk stuff. You want to get rid of it relatively soon. Flip side though, if you are providing legal services and you know that clients will disappear and come back 3-4 years later, you'll keep the personal data for longer. Now, it's a bad example, law firms, because we have to keep data for a certain period of time under our regulatory regime, but you get the point. And then finally, and the really important one, you have to store data securely. So, you know, making sure that you've got basic stuff like two-factor authentication in place, that, you know, your servers are appropriately, you know, they're run by reputable people, that they've got appropriate encryption in place. So making sure that things are not, you know, things are relatively secure. The level of security is going to depend on your business. You know, if you are basically just collecting information that is not particularly sensitive, then you don't need to have full-blown encryption potentially on every single server that you use. If you're processing personal data about, you know, that is health data, of course, you're going to have the highest sort of levels of protection. So those are the principles. The processing conditions are the reasons that allow you to process personal data. So if we take the first one, contractual performance, what this basically means is that you need the personal data of your customer in order to perform the contract with them. So if you are a ticketing platform for events and somebody wants to buy a ticket from you, you know, maybe you email tickets to people, so they get a ticket by email. You need their email address in order to email the ticket to them. Therefore, you collect the email address because of contractual performance. That's the processing condition. I'm not going to run through them all, but just for reference purposes, where I've put in brackets special, so look at the ones at the bottom, where I put in brackets special, this is a processing condition that is relevant and can be used for special category data. So, you know, biometric data, health data, all that kind of stuff. The other ones can't be used for it. So, you know, if you want to process special category data, you need to use one of those with special after it. What I do want to just do, though, is pick up on one of the other processing conditions, which is called legitimate interest. Now, for most businesses, legitimate interest will be very, very significant in terms of the reliance that you place on it as the processing condition for processing data. What this basically means is that you have a genuine and legitimate reason for processing the data, which can include that it's necessary or beneficial for your business. And the use of the data in this way doesn't cause unnecessary harm to the data subject. So there's sort of three bits to this test. Do you have a legitimate reason for using the data in this way? Is it necessary? And is there a fair balance that it doesn't cause huge amounts of harm to your data subject? So the classic example of this tends to be sort of marketing communications. So you collect personal data, email addresses, let's say, about your clients as you work for them. They're existing clients. You want to cross-sell a service for them. So, we're providing you with advice on GDPR. We think that it'd be you might benefit from our services around employment and options. So we want to send you a marketing email on that. What we do is we do that based on legitimate interest. So we say to ourselves, it's useful and relevant to you. We don't think it's going to do you any harm because it's an email and we're not going to start spamming you. That's sort of the logic there. If you use legitimate interest, you should technically do a risk assessment. And I think this is one of those areas where, frankly, nobody ever does it. But just as a sort of practical point, if you do want to cross the I's and dot the T's, you should do a risk assessment to justify use of legitimate interest. And it's really hitting on that balance point at the end of the slide there. I wanted to talk briefly about transfers of personal data outside the UK. So we've touched on this a couple of times. If you think about the slide with the overlapping jurisdictions of UK, EU, US, we were talking about how if you're working with Google, you are transferring personal data from the UK to the US. So when you are transferring personal data out of the UK, you need to understand how you are doing that lawfully. And very simplistically, there are three ways of doing a cross-border transfer in a way that is lawful with UK rules and equally with EU rules. The first one is where you transfer personal data to another country that has an adequacy decision with the UK. So the UK goes out and negotiates these decisions with other countries. And what those decisions are saying is, your regime is pretty much the same as our regime. Therefore, if people comply with your regime, they're complying with the same standards and rules as if they comply with our regime. So we can assume that transfer between the two jurisdictions is safe because people are basically bound to a very similar regime. We have adequacy decisions with the EU, Guernsey, and actually quite excitingly the US from the middle of last month. The UK government is negotiating them with all sorts of countries, and they hopefully will pop up, as and when they do. So adequacy decisions is going to be what you use for the EU, particularly if you're transferring data from UK to EU. If you don't have an adequacy decision, then you're going to have to look at either the second or the third one. So if you are transferring personal data to a third country where there isn't an adequacy decision, and this is a transfer to a third party, so to another processor or a controller, then what you're going to do is rely on something called standard contractual clauses. And standard contractual clauses are basically a sort of couple of pages of clauses approved by the Information Commissioner's Office, so the regulator in the UK, and they are based, ironically, actually, off the EU's version as well. So if you think the EU SCCs, UK ICO has adapted them a little bit, made some changes for the EU. They look very, very similar. They are very, very similar with some sort of post-Brexit UK tweaks. You will sign those probably on the back of a data processing agreement with that third-party business you're transferring personal data to. As long as you've done that, your transfer is lawful. So you've got your SCCs in place, they've been done properly, you've got a lawful transfer to that third country. I would say probably for most third country transfers, most of the time SCCs are the way this is done, by the way. So if you are transferring to countries that we don't have an adequacy decision, a data processing agreement and SCCs is very, very likely where you end up. The final sort of route is using something called binding corporate rules. So these tend to apply for multinational companies where they've got different entities in different jurisdictions. And what they do is they allow, it's a contract that is put in place that basically says the company in non-equivalent jurisdiction will comply with this agreement that imposes equivalent rules to, say, the UK. So if you're transferring personal data to I can't think of an example, XYZ big company, let's say Amazon, for whatever reason, they are going to transfer some of your personal data across to Peru. Peru doesn't have an adequacy provision with the UK, and therefore they may have binding corporate rules that impose that protection. So that's the other sort of way of doing this. When you're due diligencing third parties who you're going to send personal data to, what you should be looking at is obviously their website. Have a look at their privacy policy. So there's always a legal section on, well, not always, but most of the time there's a legal section on people's websites. There should be a privacy section. And if you read through either the privacy policy, there'll be a section on third country transfers, or there might actually be a separate section within their legal bit around third country transfers. You'll generally find the way they're doing it there, and it will most of the time be SCCs. Sometimes you might find binding corporate rules. In terms of documentation, there's always a bit of thinking on your side as to what you need. So mostly businesses will need a privacy policy. So this is that, I'm sure all of you have seen them on websites, may or may not have read them, but this is a document that sets out the personal data that is being collected from data subjects, what the business is doing with it, the legal conditions for the processing, your rights as a data subject. So all of that information is up there. And this is meeting the requirement to provide information to your data subjects about what you do with personal data. That, though, is not the end of the story. And I think this is one of the big mistakes that startups make. They think we need to do the privacy policy, tick, that's it, we can forget about it. It isn't. So the other things you need to be thinking about: privacy clauses or a data processing agreement with your suppliers. So, if you think about Gmail, right? You will say, well, hold on, Gmail, Google is processing personal data. Are they doing this in a way that is compliant? Well, we've had a bit of a look at their privacy section. They are processing our data in the US. We have an adequacy decision with the US, therefore we're happy. But you've perhaps got a CRM who is based in Peru. Peru doesn't have an adequacy decision, so we need to figure out how we got that sort of lawful transfer. And as I said earlier, you're looking at their documentation to understand that. The people who process personal data within your business, employees or contractors, are actually the people who cause the most problems here. So there's a very good chance if there's a data breach, it's one of your team who's done it. Not deliberately, obviously, but just because they've got something wrong, they've done something stupid, they've taken a bunch of data out of the office and left it on the tube. So employees and contractors are the biggest cause of problems here. So what you need to do to protect yourself is ensure that in your employment contracts and your contractual agreements, there are clauses that say you will comply with our policies on personal data. So you won't, for example, download all of our client personal data onto a memory stick and take that out of the office, because you could leave it on the tube, or it could get stolen, or something could go wrong. Behind the employment contracts and the contractual agreements, there is then a set of internal policies that dictate what employees are expected to do, what they can do, what they can't do. Whilst talking about employees, it's also actually worth saying you should really have a separate privacy policy that explains to employees what data you're going to process as you recruit them and as you go on with their employment, and what rights they have in respect of that. So we generally advise that clients, when they send out the employment pack to new candidates, so employment contracts, benefit stuff, anything else that's going out with it, that they also send an employee privacy policy with it, and ideally get that signed. What other stuff? So we sort of touched on the idea that if you're transferring personal data to third countries, you're going to want to think about data processing agreements and standard contractual clauses. if you're using legitimate interest as a processing condition, you're going to want to have risk assessments. There's a whole bunch of other areas where you may want to do risk assessments as well. So, particularly if you're using, high risk special category data, you're going to want to do a risk assessment around, where does that data end up? Who else uses it? If you sign a new contract with somebody to process data on your behalf, it may be appropriate to do a risk assessment to make sure that their processes are compliant as well. And obviously, the more you do this documentation, the better protected you are if something goes wrong. And I think that really is probably the key point here. The more upfront work you do on this stuff, thinking exactly what's going to happen, thinking about who's processing data on your behalf, what risk assessments you want in place, the more you do that, the better you're going to be protected if and when something does go wrong. So this is not a waste of time, even if customers don't necessarily see the documentation. Just on the right-hand side, a couple of sort of key points. So precedents are wonderful things and can save a lot of time. And I think in this particular space, they are potentially more useful than in sort of other areas where, where they can be a little bit riskier. What I would just say, though, is number one, make sure you use a decent precedent. The irony is very often that a lot of these platforms, these precedent platforms that are selling you cheap-ish precedents, they're not actually giving you good starting points. If you're looking to do this yourself, you're looking at precedents, actually go on the ICO's website. All their content's free. There's a whole bunch of really useful stuff there. I would say probably a better starting point than one of these precedent websites. Remember, if you're going to use a precedent, that every single business is different. And just because one of your competitors is saying that they do X, Y, and Z does not mean that that is correct for you. And to just give a super simple example, you could have let's say two law firms, right? You could have two identical law firms. One of them could use Gmail for emails. Another one could use Hotmail, Microsoft for emails. The risk assessment on those is different. The data goes to different places. There'll be different servers. There'll be all sorts of different stuff going on. You need, as a business, to make sure that you've thought about this stuff yourself and you haven't simply copied what somebody else is doing, or assume that a precedent is necessarily getting this stuff right. Second point, compliance isn't just about ticking boxes. And I think the biggest mistake that businesses can make here is just going, we just need to do a privacy policy. Let's make it look okay. That will be fine. It may be fine until it goes wrong. And when it goes wrong, you are putting yourself at a bit more risk. You are permitted, as we talked about, to take a risk-based approach. So, don't start spending hundreds of hours and huge amounts of lawyer time if the only data you're processing is an email address and you're not going to do anything with it. Flip side, as we said, if you're collecting all sorts of special category data, then think about it, worry about it. That's much riskier. You need to be doing more heavy lifting to make sure you're compliant. And the final point is just don't forget the risks of non-compliance. You can be fined, reputational damage, all that sort of bad stuff that we talked about at the beginning. In terms of managing risk, it's not rocket science, I think. A lot of this stuff is quite obvious, but there's sort of two bits to it, right? Firstly, think about the risk inherent in your business from a personal data perspective. So, you're entitled and encouraged to take a risk-based approach, but you can only rely on taking a risk-based approach if you've actually thought about the risk and identified it. When you're thinking about risk, record it, put it in a report, save it somewhere, demonstrates to a regulator, or indeed in court of litigation later, that you genuinely did some thinking. The biggest sort of catchphrase in this space is, if you didn't write it down, you didn't do it. So write everything down. I would say review your risk assessments, review your data protection position once a year. Even if that is you and your co-founders or your CTO, whoever it might be, sit down once a year, talk about it, figure out things that have gone wrong, figure out things that have changed, things that need to be updated, put it down in a board minute and put it in a file. It's better than nothing. And that gives you a degree of protection and hopefully actually improves your processes. And when considering risk, don't forget special category data and the greater sort of risks and obligations that go with that. The second point here, self-evidently, is about minimizing risk. And I think really that comes down to these four things. So making sure that in the background, behind your privacy policies, you've got policies and procedures that are appropriate to your business. So explaining to your employees what they can and can't do with data, what they're supposed to do in terms of security. So yes, they should have two-factor authentication set up on all of their software. No, they should not be downloading client personal data to their personal phone or their personal devices. No, they shouldn't be taking chips of client personal data out of the office. So those sorts of basic security things, put them in a policy, make sure your team comply with them. Training of staff is absolutely vital. As I said a minute ago, the biggest cause of problems here is your staff. They are the people who, unfortunately, completely inadvertently get stuff wrong and cause you a problem. So make sure that you do regular training. Ideally, that's internal training tailored to your business. But if you don't have the time or you're not confident enough to do it, there's a whole bunch of external training providers. You can do online seminars that your team can view. But again, get it in writing. So get an attendance note signed by everyone who does it, so that in the future you can demonstrate they were trained on data protection. And in an ideal world, do that at least once a year. Again, I would say try to have a continual conversation about this and try to make sure that training is on an ongoing basis. But I get that can be a pain in the proverbial. So once a year is probably the sort of minimum, if you like. Privacy by design is what we talked about at the beginning. So building a good data practices into your products and services from the get-go. It's so much easier to do it as you set up a business than to try and figure it out later. Retrospectively, building this stuff in is super painful, as lots of lawyers figured out when GDPR actually came into force. We had lots of clients who did nothing. They got all their processes in place, they got their client sign-on processes, and they would have to retrospectively build a whole bunch of stuff on top. Very painful, very expensive. If you can do it up front, it makes life so much better. And finally, you need to understand what it is you're doing with data. We talked about this, but you need to understand it. So as a sort of summary there, if we go around on a clockwise basis, your first job is identify the personal data that you're processing. You then figure out the legal basis, so the legitimate interest or contractual obligation. Having figured that out, you need to figure out where the data goes. So are you transferring it out of the UK? Particularly, are you transferring it to countries that don't have an equivalency regime? You then need to think about your documentation. So you've got your privacy policy. You may have data processing agreements, SCCs, that you need to put in place to make sure that everything is compliant with the law. And finally, and most importantly, and the bit that a lot of people do miss, you need to make sure that your team actually understand what the hell it is you've just done. So having beautifully crafted legal documents and data protection documents isn't actually is not actually the end goal. The end goal is to have policies and procedures that are implemented throughout your business. So make sure that having put this stuff together, you train your team on it, you make them understand it, and they actually comply with the policies. And then in an ideal world, this is a continual loop. So as you introduce new goods and services, you're thinking what personal data is going to be processed with these goods and services, what's the legal basis, blah, 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 blah. And you just go round and round and round this loop on a regular basis. That is enough from me. If you've got any questions, chuck them into the box and Ivan will ask them.
Perfect. Thanks so much for that overview, Michael. I hope that everyone found it really useful. We do have quite a few questions, and the first question is from Ben. He's asking, do I need a privacy policy if I only collect emails for marketing purpose?
So, well, the answer is yes, but it's sort of not, it's potentially not a massive priority. So I think when you collect the emails, so the classic example of this is, before you launch your platform, you have a holding page, right? And that holding page says, pop your email in, we'll send you updates on launch. Generally what you would do is you'd have a box underneath it saying, by putting an email address, you consent to receive targeted promotional communications. you should, and you are required to have an explanation of what you're going to do with that personal data. And so to that extent, yes, it's a privacy policy. But if what you're doing is incredibly straightforward, it doesn't need to be a sort of 10-page document. It can be a sort of one-pager that says, we're going to collect your email address. We are only going to use it to send you targeted emails about launch. We will only send these for 6 months. Once we launch the business, if you haven't signed up to the platform, within 3 months, we're going to delete your email address. If you do sign up to it, then it'll be subject to our privacy policy that we will eventually launch. So something like that, absolutely fine. You don't need to go completely crazy on it.
Perfect. Thank you so much. Guys, just before we continue with the questions, I'm getting lots of questions in the chat box about the slides. I'm responding to them, but if you want to get a copy of the slides, just email office@buckworths.com and someone will send them to you. So it's again office@buckworths.com. Next question is from Kel, and Kel is asking how long I can keep personal data for.
Yeah, so the answer is it depends on your business, and it's really getting back to this point about how long you need it for. So there's no absolute rule set out in legislation. So there's nothing that says if you keep it for 5 years, it's fine, but keep it for 5 years and a day, you're going to go to prison. So it's always going to be very much based on what you need. What I would sort of say is, in an ideal world, what you want to do is build in a process that reviews your users or reviews your customers, and has a sort of an approach to deleting data when you stop engaging with them. So if you're operating an online platform, you may know, it may take time to figure this out, but you may know that actually, if people don't interact with your platform for 12 months, then they're never going to come back. They're over it. They've had enough. And you might say to yourself, well, all right, we'll give it 12 months, and then we'll send them perhaps a note saying we're going to delete your personal data. Hopefully you've put this 12-month limit in your privacy policy as well. Send them a note. If they don't interact, we'll delete the personal data 6 months later. Other businesses may take the view, well, actually, we know that people stop interacting with our platform, but then 3, 4, 5, 10 years later, they pop back up. Now, I would say you probably don't just want to sit holding that data for 10 years, but you can prod people. So you can send people emails saying, do you still want your account? Do you want us to delete your data? And I guess if your policy perhaps says you send 3 emails a year, don't get a response after 3, 4, 5, 6 emails, perhaps you delete at that point. So I think the point is, it's up to you, but you need to have thought about it, have a policy in place, and as best you can comply with the policy.
Perfect. Thank you. So we've got a few more questions, guys. It has been a really busy event, so I'm going to pick another 5 questions probably. The next question is, what do I do if someone asks me to delete their personal data? And that's from Richard.
So data subjects have a right to request deletion of their personal data. In most circumstances, you would comply with that, but not all circumstances. So, there are circumstances where, and this, by the way, comes back to the processing condition that you have relied on to collect and process the data in the first place. And some processing conditions force you to delete, others don't. If I just give a practical example of sort of a circumstance. So, we're a law firm. We process personal data about our clients and about shareholders in our clients. One of the reasons that we process personal data about shareholders in our clients is because we have a legal obligation to carry out money laundering checks to make sure people are not criminals, terrorists, sanctioned. We are required by law to keep that money laundering information for 6 years at least. Our policy is to keep it for a little bit longer than that. If I collect a bunch of information about you in compliance with our money laundering obligations, and you then send me an email saying, I require you to delete that, we will say, no, we're not deleting it because we collected it on the processing condition of legal obligation, and we have an obligation to retain it. So that's an example of a circumstance where you wouldn't agree to it, and you would explain to the client why. Circumstances where you do agree to it. So the classic one that we work with lots of recruitment companies. They will pull personal data about candidates from job portals, pull their CV, and then when their system identifies that that a job is potentially relevant to them, it will send them an email saying, hey, we think this job is relevant to you. Let us know if you want to apply for it. People will often come back to them and say, don't know how you got my data. I don't want you to have it. I don't want to receive these emails. Please delete the data. And in those circumstances, in most cases, recruitment companies will just simply go back and say, that's absolutely fine. We've deleted the data. You won't receive any more emails. So it always depends on circumstances.
Perfect. Thank you so much, Mike. We've got a question from Stefan. Does DP regulation apply to information about organizations, for instance, a company's email, if you are a B2B business?
So the answer is possibly yes. So a business email can identify an individual. So if you think about my email, right, it's mbuckworth@buckworths.com. That identifies me. It's clearly it clearly identifies me. It is personal data. So you know, business email in that case would be personal data. The flip would be info@buckworths.com. It's a generic email address. It doesn't identify anybody. That probably isn't personal data. So as a business, your judgment is probably, do you assume that all emails are personal data because some of them are going to be, and you just imagine that everything is? Or do you actually say, effectively, we're going to check every single email address and separate out business info@ from mbuckworth@? mbuckworth@ personal, info@ isn't. Most businesses just lump it all together and say it's all personal data, and they apply that level of protection to the whole lot.
Perfect. Thank you, Mike. And sorry, one more question from Stefan. Can you use third parties companies' logos on your own website without asking permission, for instance, to talk about their product of offering in a blog, in a review, etc.?
So that's not actually necessarily a data protection question. It's probably more a trademark question. So most people's brands and stuff like that is a trademark, and they've got a trademark. If you use a trademark in a way that is unauthorized and unlawful, then you commit trademark infringement, and they could theoretically sue you for damage that you do to their brand and for infringing their trademark. It very much depends what you're doing. As a rule of thumb, you can generally, it's not particularly risky to pop the logos of clients or people that you are working with on your website. So as an example, it's very common to see, like marketing agencies, they put logos of like HubSpot and this kind of stuff on the bottom of their website, and they say, we're a HubSpot partner. I think HubSpot's probably a bad example, because I'm pretty sure that actually within an agreement with HubSpot, they specifically allow you to do that. But you get the idea, like people do that kind of stuff. In most circumstances, if that's all you're doing, if the brand has an issue with it, you're going to get a pissy legal letter from lawyers saying you're infringing the trademark, take it down or we will sue you. And of course you will take it down. So it's generally fairly low risk. What you wouldn't want to do though is use a brand in a way that is, misrepresent something. So you wouldn't, it would be very silly, but if you're a, this is a very bizarre example because my brain is in the wrong place, but you're a restaurant that is selling burgers. You wouldn't want to put the McDonald's logo on the top of the website, because McDonald's would get super upset and say you are trying to confuse customers into thinking that you're us. So that's that point. In terms of the personal data thing, it's probably only really arises when you put sort of individual details on. So, for example, you suddenly put on your website my personal email address and a picture of my face and say, this business is supported by Mike Buckworth. I may or may not have an issue with that. So I think that kind of stuff I probably wouldn't do without at least asking permission. Yeah.
Perfect. Thank you, Mike. We have a question from Dean. How would anyone know if GDPR has been breached, and if a business got hacked, will the owner be held liable despite having a top IT security?
So how do people know? In terms of hacks, it's sort of self-reported. So if you get hacked, you have to make a judgment call as to whether there is a material serious risk to data subjects. So, being flippant if 10 of your clients' email addresses have been, accessed by somebody, you would probably conclude it's not a material issue. Flip side, if you're a medical tech provider and everybody's medical records have been hacked, you would conclude it's a pretty big issue. If there is a material issue, you have a legal obligation to notify data subjects, and by the way, to do that pretty fast, and potentially to notify the regulator, to notify the ICO. If you don't do it, you greatly, massively make the position worse. So getting hacked is one thing, not reporting it is a completely different, much bigger scale problem. Just to help you guys understand, it's very rare, not entirely impossible, but it's very rare that businesses actually get fined by the ICO for being hacked. Normally they get fined for not telling data subjects they've been hacked and not telling the ICO they've been hacked. So that's where the penalties normally come in. So you need to think about how material it is and whether you need to notify. In terms of where the liability sits, I think normally it's the business that's liable, so it would normally be a claim against the company. There are circumstances where directors could be liable. So if it was sort of gross negligence on the part of a director, being really flippant, you got paralytically drunk, and you decided to, give the little bike thing that they, the Soho bike driver, all of the personal data about your customers because you thought it was a lovely thing to do, then yes, you could be personally liable. But in most circumstances, it's unlikely. If you are worried about personal liability, it's worth having a look at directors and officers liability insurance, covering something slightly different, which is the negligence piece. And you do need to read the policies to make sure they do cover data protection breaches, because some of them carve it out. But that's the sort of the thinking there. So yeah, personal liability, moderately unlikely. Yeah.
Perfect. Thanks, Mike. We've got a question from Suleiman. If a data subject UK offers data involuntary to your company or business, data processor, controller, will a general privacy notice cover any grounds for the involuntary data captured received?
So sorry, if a data subject offers data involuntarily to your company, will a general privacy notice cover any grounds for the involuntary data? So I guess that we are thinking about a situation where perhaps, there's personal data about a data subject online are publicly available, and you sort of grab that and start using it. So I don't know, you go on my website, you go on the firm's website, you see my email address, and you start sending me marketing communications on the basis that stuff is public. I think if that's the kind of situation you're thinking of, you need to be careful, because just because something's public does not mean that you can do what the hell you want with it. It is still personal data. You still have to comply with the rules. I think it's true to say that you would probably, by the way, you'd probably rely on legitimate interest in the example I just gave you. And it's certainly helpful if somebody's put their information in the public domain, because it enables you to assess the balance of risk better. You can sort of say, well, they made the personal data public, so shouldn't be a surprise to them that, people are using it. So it helps. In answer to the narrow question about the privacy policy, yes, you should be setting out in the privacy policy what you will do with that data. And what the rights of the data subjects are. So, yes, if you've pulled my email address off the website, I still have the right to ask you to erase it. And if I ask you to erase it, then you will delete it. So you would want to cover that stuff off in the privacy policy, even if you've got information, some other way.
Perfect. Thank you, Mike. I'm going to take final two questions. And the next question is from Nick. Which of the following apply? UK GDPR, EU GDPR, APP, API, if the company is in Australia and the web platform data is based in Germany and the users are in the UK and Australia?
So let's have a look. So you have got users in the UK and Australia. So you're subject to the UK and Australian regimes because that's where the data subjects are located. The platform data is based in Germany. So I think probably what we're saying is that the personal data is processed in Germany. So you've got servers in Germany and stuff is happening in Germany, meaning EU would apply. And the company being in Australia, it does that's a question actually for the Australian regime. I suspect it brings you in any event into the Australian regime, but that is probably something just to double check. So it sounds like UK, EU, Australia all apply. One point just on Germany. So Germany is a particularly fun jurisdiction when it comes to this kind of stuff. Obviously, EU GDPR applies in Germany, but the German courts have gone above and beyond in a number of areas. So the areas that you need to be a little bit more careful about are things like, well, it's marketing emails. So things like, you know, if you're perhaps a goods company and you're selling stuff, products, dog boxes, and you send an email to your customer asking for a review and for them to, you know, give you a review for the product. In Germany, that is a marketing email, and it is a criminal, or it's unlawful at least, to send a marketing email without the data subject's consent. So Germany has got a bunch of additional stuff above and beyond sort of standard GDPR considerations.
Perfect. Thank you so much. And the final question is from Selma. If your website was hacked and the customer data was stolen, what would be our responsibility to our customers from a legal point of view, taking into consideration that we had a secure website database?
Yeah, I mean, it's going to be very fact specific. I mean, there's a slightly flippant answer I could give, which is that if your website's been hacked and they've accessed data, then it wasn't as secure as you thought it was. And I think the important distinction here is between your website going down, so denial of service attacks, which doesn't involve a data breach. They just take your website offline effectively. And I'm actually getting inside your databases and accessing them. The sort of key things to think about there are, and particularly when you're sort of designing these things, you know, there's ways that people can get through your website into databases. Once they get into the database, that, you know, just because they've got into a database doesn't mean that they can necessarily see the data. If the data is encrypted and they haven't got the encryption key, it shouldn't really matter, simplistically, that they're in the database in the first place, because they can't access the data and therefore there isn't a breach. There's a security breach, but not a data breach. I think in terms of liability, and sorry, actually, in terms of making sure this doesn't happen and protecting yourself, you know, what is a very, very good idea is getting some penetration testing done. So this is where you've got what people loosely call ethical hackers, who will do their very, very best to hack your website, get into it and access personal data, but they're obviously doing it for you on your behalf to test your systems rather than actually nicking the data and doing bad stuff with it. So doing penetration testing is a super good idea because it actually gives you that evidence that not only did you build a platform that you believed was secure, you actually had somebody try and hack it and demonstrated that it really was secure. Above and beyond that, look, stuff happens, things go wrong. You know, it is what it is. Whether you are fined is, at the end of the day, a judgment for the regulator. As a rule of thumb, they don't dish out fines unless you've done something objectively bad or reckless. So if you've got, you know, market standard security systems, everybody's doing their job right, you've got two-factor authentication in place, you know, you've done penetration testing and all the other stuff that we've talked about, and somebody still manages to get into it, well, fine. As I say, I think most of the fines in this space don't come from the hack itself, they come from not telling data subjects about the hack. So, you know, I wouldn't be overly sort of worried about this kind of stuff. What we haven't talked about is the increase in litigation against businesses by what, I'll be honest, I view as slightly naughty lawyers. So this used to be primarily the reserve of US lawyers. It's these sort of class actions have come to the UK now. You've seen all the PPI stuff and all the diesel fuel stuff in Mercedes and Range Rovers. You've got the same sort of thing with data breaches, where lawyers get together class action of people whose data has been stolen and they bring a claim for it. It's not something I think to be massively paranoid about, but it is something to be aware of. You can get insurance to cover this kind of stuff. So it's worth, when you get your business insurance, to have a look at the bolt-ons for data breaches. A lot of the insurance in this space is not that great, with lots of exclusions and quite low cap limits on it. So you do need to read the policies, but that's something you can do potentially to sort of protect yourself if that's if it's something you're worried about.
Perfect. Thank you so much, Mike. We had lots of questions tonight. Again, guys, if you have any extra questions or you would like to continue the conversation with Michael, or you want the slides from tonight, please feel free to email us at office@buckworths.com, and someone will either organize a call with Michael, or you can ask him questions by email, or send you the slides. Thanks so much for joining us. If you enjoyed the GDPR event, our next event is in January, 25th of January, on Introduction to Startup Law. Michael is going to discuss all the legal bases that you need to be aware of as a business in order to drive your business to success. It's an in-person event in Mission Works. It will be great. Lots of people are coming. There will be lots of networking at the end, talking to the experts, talking with Michael as well. And Michael hasn't mentioned that the presentation, he wrote a book, Built on Rock. It was a bestseller on Amazon. Currently, chapter 1 is available to download for free on our website. We're also running a special promotion on Amazon, so it's currently discounted on 50% for Black Friday, so you can get that either on Kindle or the hard copy, and there are lots of insights on running your business successfully. Thanks so much, and we hope to see you soon. Good night.
Thanks, guys. Bye-bye.